For world boss is a must right about now. Let me tell you this. In the report, yeah, we get to find out say yo, the Jamaican justice system fuck up. Right about now, you know, it looks sticky upon the Jamaican justice system.
Mr. Buchanan.
If it pleases the court, Lords and ladies, I just wish to make a point, a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones, and this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings, the concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true, and then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman, and more conversations about her role, and so the taint or the poison would have gone back as far as November in a 65-day trial, and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked what their responses would have been for the judge to make an informed decision. And I say this in the context that, in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is, when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso unjust. It's just not possible. It would have been an absurdity in the law. Now, in relation to Lady Simla, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time it was presumption of constitutionality, and certainly the onus was on the appellant to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that, Lady Simno would have asked, is that the judge now has a duty to carry out the Oakes test or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable. So,
can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, it's part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is right? Correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
Oh,
but
right.
What is significant?
Check my notes.
Right. What is significant that comes from it is that, and we take pride in this. And I'm quoting, I'm paraphrasing our Chief Justice, and it's found. Thank you. It's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society.
Yes.
Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of the circumstances in Jamaica? Or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21.
Yeah.
But what's significant is that what is clear is that there is similar to in the Canadian jurisdiction that the test, which is the demonstration
Definitely like, share, and subscribe if you are new to this channel. As me say, if you want to be a part of the video, anything at all business related, link them up on Instagram, the 826 Blitz. You know the vibe, a mad move right now. Tune in for the case.